The information contained in this video is distributed free of charge for educational purposes. Whilst we have taken all reasonable steps to ensure that the information contained herein is correct and up to date, insofar as the law in South Africa is concerned, the law remains a nuanced and complex field of study, replete with many exceptions and conditions. Please, therefore, do not utilize this information as legal advice, which it is not. When in doubt, consult with a legal professional. For more information, please feel free to contact our offices.
Right, good morning everybody and welcome to our workshop webinar today. Welcome to everyone specifically who's joined online and for the few who've joined me here in person who are just off screen having their brekkie. Welcome. Thank you so much for joining us today. I really do appreciate it. My name is Vermeulen. I'm an attorney. I will be conducting the workshop today. And today we're going to be talking about matrimonial property law in South Africa. Now, just a few issues of housekeeping. I know a lot of us are struggling with load shedding countrywide. We've also got load shedding coming up in about 2.5 hours on this side. So I am going to keep a fairly brisk pace going through the course material. If anyone gets kicked off for bad bandwidth or load shedding, etc., please do not fret. I am recording today's session and it will be made available to you. So, today's agenda, we're going to be looking at an overview of the matrimonial property regimes in South Africa. Call it Matrimonial Property Law 101. We're going to be looking at marriages in community of property, out of community of property, both including and excluding the accrual, as well as some of the attributes and unique characteristics of these matrimonial property regimes. Then we're also briefly going to look at proprietary rights of unmarried persons, as well as forfeiture of patrimonial benefits, whereafter we will be going into a question and answer session, time permitting. We have a large number of people registered for today's webinar. Not everyone has signed on yet. We will, in terms of just exercising our discretion to make sure that we do cover all the material, we are requesting that people rather ask their questions in the chat box rather than in person. We will have proper in-person vocal question sessions at a later stage for you to unmute yourself, show us your lovely faces and ask us whatever questions and open it up for discussion. I do request, however, as we go through the course material, that you would limit your questions and comments to the chat box provided. I have my co-director, Entail, who's very active in our family law department, standing by to answer any questions that you may have in the text bar. So please feel free to raise these questions. And I've also got Cara Scully, my candidate attorney, assisting Entail to monitor the chat box. So please feel free to utilize it. For those who are comfortable doing so, you're welcome to just insert in the chat box who you are, what you do, how you heard about these webinars, and if you would like, use this as a bit of a networking event as well. Obviously, this is not mandatory. You are welcome to do so if you are comfortable. Right, just in terms of house rules and etiquette, just to make sure that we run a well-structured agenda today, please use your real name for register purposes. Please feel free, as I said, to type questions, comments in the chat box at any time. We will deal with as many as possible. Respectful discussion, dissent, and comments are welcomed. All of us are family law professionals working in some sort of capacity in the realm of family law. That is why we are here. We all have a wealth of information to share with one another. I don't purport to know everything. I am, however, an attorney in active practice, and I have a passion for hosting these types of sessions. If you disagree with me on a particular point, please do raise that in the comment box. I am happy to discuss and or debate with you in the appropriate time. Very, very important, and we have a zero tolerance policy on this. Please keep discussion respectful, avoid hate speech, victimization, or belittling attendees. We are all here to learn. Then finally, very importantly to me, please do not record or distribute the contents of these sessions to persons who did not attend. We will be, as I mentioned earlier, recording this session and making it available on various platforms for people who are interested in seeing what was discussed and viewing the course material. However, we spend a lot of time putting this material together, and piracy really does impede our ability to feasibly host these sessions in the future. For your information and for those who are interested, we will be this year looking at running approximately 2 webinars per month, probably on the 1st and the 3rd Friday of each month, and I will in due course obviously convey the information regarding the further webinars to everybody. Right, so one of the reasons I do these webinars, for those of you who have your cell phones handy, please open up your camera now and scan the QR codes on the screen. The one on the left is my business card, together with my personal cell phone number if you would like to connect. And further, the one on the right-hand side is my LinkedIn profile. Please do feel free to add me. LinkedIn is one of the big distribution channels that we utilize to send out this type of material. We do release information about webinars, blogs, and information which you may find useful in your practice via LinkedIn. Right, so ladies and gentlemen, without further ado or housekeeping, let's talk about POTS. Now, in this session today, in talking about matrimonial property regimes, I want you to imagine a pot. Every time you see a circle on the screen with assets and or liabilities, imagine a pot. One of my physical attendees this morning said, well, we must be careful which pot we are talking about. We are not talking about pot, we are talking about pots. We are not here to discuss the work that Gareth Prince is doing down in the Cape. We are here to discuss matrimonial property. So why do we use the example of pots? Well, quite simple. It is a very, very convenient allegorical manner to understand this for ourselves, but also to explain this to clients. Clients do sometimes find it quite difficult to understand matrimonial property regimes, and this is a very, very easy way of simplifying the information for them. So one of the purposes of today's webinar is going to be to see how far we can actually extend this metaphor to the point of absolute contrivance. So let's get started. Right. When we talk about POTS, we talk about matrimonial property regimes. And in South Africa, we have 3 main situations. Number 1, we have a marriage in community of property. There you will see the cutout people from Microsoft Office standing on the right and left, and incidentally, the people were chosen for their expressions and the hand signals that they make, not for any identifying particulars regarding race, religion, gender, etc. But here we have a couple, presumably married and married in community of property, with the one pot in the middle containing all of their assets and liabilities, namely a vehicle, a house, a piggy bank representing cash savings, the cash exchanging hands, representing your personal loans and unsecured loans and debt, as it were, and also the credit card at the bottom. So let's go on to a marriage out of community of property. Now you'll see our couple here are both rocking very, very beautiful, very jolly smiles because they are safe and comfortable in the knowledge that their stuff is their stuff. You will note that there are two pots here rather than one. They are each stirring their own pot separately from the other, and they do not have any claims against one another. So this is our marriage out of community of property, specifically without the accrual. Then after we've had the two very, very simple scenarios of the one pot in the middle and the two pots on the side, we sit with a situation which our legislature in all of their wisdom dropped us in and made our lives extremely difficult, being the accrual. And the accrual is a particularly problematic one, which we will be discussing in quite a bit of depth today. I will also be looking at how to do an accrual calculation. So if you want the dubious privilege of seeing an attorney do mathematics, please do stick around. And if any of you are financially inclined, please do feel free to correct me if I'm wrong. My particular accrual calculation, I have been advised by people who are much cleverer than I and in the financial sphere, is however accurate in terms of the legal principles. Now, what we look at here is we see on the left-hand side two pots, both of the same size, representing a commencement value and an ending value. Let's suppose, if we follow the direction of the arrows, and I'm going to draw here on my screen, that is the commencement value of party number one, and this is the ending value of party number two. As you will see here, it stays roughly the same. However, if we look at the picture on the right, we sit with a much smaller commencement value and a much higher ending value. So our spouse on the right has
Sorry, Mervyn, we can't see your screen. Could you share your screen?
I am sharing my screen. I'm just checking here. My screen is shared. Doris,
Yes,
has
we
anyone
can
else
see
got
it.
difficulty seeing my screen on their side?
No, we can see it.
No, we can see. Okay.
Sorry, I'll go out and come in again. Okay.
Okay, not a problem at all. Thank you for alerting me. All right, so if we look at our position on the right, we sit with a much smaller commencement value and a much higher ending value. That entails our commencement value being, i.e., at the start of the marriage, and our ending value at the end of the marriage. Now, accrual is constituted by the difference between these two figures. What is accrual, therefore? Accrual is a deferred, and please do forgive my terrible handwriting on the screen, method of sharing in growth. What does that mean? It does not mean that everything that you have prior to the marriage stays your own and everything after your marriage becomes part of a communal pot, as is the case in many countries in Europe, and is the misconception amongst many people and even legal practitioners. Understand, folks, that an accrual claim is a claim in cash money. That's why I've got the arrow in the middle there that will show the cash payment from the one spouse to the other spouse. That claim, ladies and gentlemen, only arises upon the transpiring of one of two events, the two Ds, death or divorce. In other words, during the marriage, both of our spouses here have absolutely and I say semi for a reason, unfettered powers to conduct their affairs within their estates as they deem fit. Incidentally, for those who cannot see my screen, Quinn, can I ask you to just ask Bianca to sign in and just share our slides on the chat so that those who can't follow on the screen can at least open it in their own PowerPoint. Right, so we'll hopefully sort that out shortly. Right, so those are the three formal matrimonial property regimes in South Africa at a very, very quick glance overview. What I would like to do now that we've taken the fairly high level overview of it, is let's go into a bit more detail in respect of each of the positions, starting with our marriage and community of property. Now, imagine, if you will, we sit with two spouses on one side. Oh, my apologies. Let me just swipe back. Thank you. Okay, palm rejection is fine. Imagine, if you will, two spouses getting married. They decide to get married in community of property, and they both look after this one pot in the middle. And let's refer, I think, for purposes of today's discussion, to all our couples by either John or Jane, or John and John, or Jane and Jane, whatever the case may be. So John and Jane have gotten married here in community of property. You see, they are both still smiling. That means they have just gotten married. They are not looking at a divorce just yet. Very often, unfortunately, these smiles fade. The minute John and Jane say "I do" and they sign the marriage register with the marriage officiate, at that moment, their separate estates cease to be. In the words of the great John Cleese from Monty Python, it is an ex-separate estate. It has ceased to be. It has gone up to join the choir invisible. Once these separate estates have ceased to exist, a new entity comes into being, and that is known as a joint estate. Now, what are the attributes of a joint estate, and how does it work? So, here are our important characteristics of a joint estate. Please note, these slides will be shared. We'll share them shortly, and we will share them afterwards as well. So you will have this as a nice cheat sheet, crypt note to utilize in future. The characteristics of a marriage and community of property really come down to three aspects. And I hope you can see my screen over here. My pen seems to be seems to have decided to do the laser pointer thing rather than writing, but that's fine. Number one is that there is community of property. Number two is the element of co-administration of the joint estate. And number three, very importantly, is the fact that this is a default position. Let's start from the bottom, working upwards. It is a default position in that you do not require an anti-nuptial contract to be married in community of property. In other words, if you say "I do," and if you sign the marriage register with your officiate before you cut the cake, and you have no anti-nuptial contract, you are married in community of property. Your separate assets and liabilities immediately become the joint assets and liabilities of the joint estate. In terms of the Matrimonial Property Act of 1984, there is co-administration of the joint estate, and we will be looking at some of the powers and limitations in a joint estate a little bit later on. But basically, for now, what you need to know is that both parties are co-administrators of the joint estate. Some of you sitting here today, without having to give away your age, will still remember the marital power that existed prior to the 1984 legislation, where there was a gross disparity, unfortunately, at that stage between the powers of husbands and the powers of wives in a joint estate. Fortunately, the Matrimonial Property Act came along and changed that, and it abolished the marital power to the extent that if there is a marriage in community of property, both spouses, husband and husband, wife and wife, have the same powers in respect of the joint estate, and they are equally liable for the obligations of the joint estate. So in other words, if party A opens up a shop account with Pick n Pay and buys groceries to the value of 10,000 Rand on credit, spouse B can also be held liable. Now, that follows on from the fact that there is what is known as community of property. That means that there is one communal joint estate. That big pot that we looked at earlier, and I'll scroll back to the slide if my tablet will allow me to do so. I hope it will. Yes, it will. There we go. We have one communal pot sitting in the middle, which is our joint estate, which contains all of the assets and the liabilities which accrue to the parties in undivided over there and equal half shares. That is in respect of the assets. In respect of liabilities, the parties are jointly responsible for the payment of same. Let me just go back to pen mode over here. That's going to make my life much easier. Right. So there are still exclusions from a marriage in community of property. Two specific ones of which you need to be aware. For those in the mediation space, this is one of those things where you are going to see a lot of clients being very, very angry with one another because spouse A says, my mom in her will left me X and I don't want you to share in it. Now, be aware, in those cases, mediators ask for a copy of the will because that asset could very well have been excluded under the will in a clause to the effect that the benefits accruing to the said so-and-so, John or Jane, whatever the case may be, under this will are specifically excluded from any accrual calculation or any joint estate, which means that those assets are then separate from the joint estate. Secondly, be aware of Section 18A of the Matrimonial Property Act, 88 of 1984. Just for ease of reference, I'm going to refer to it as the MPA from here on in. So don't think I'm talking about the NPA. We're not prosecuting anyone or anything here. We are talking about the MPA, the Matrimonial Property Act, which is really cornerstone legislation in terms of what we are discussing today. Don't fret. Don't go Google it now. Don't jump onto Safely or Juta or LexisNexis. I will distribute it with the slides at a later stage. Be aware, for our present purposes, however, that in terms of Section 18A of the Matrimonial Property Act, claims for damages excluding patrimonial loss are excluded. Now, what is patrimonial loss, ladies and gentlemen? It is simply this. If I am in a car accident and my car is written off, that is a patrimonial loss. The car was an asset. The car is no more. It has ceased to be. It has joined the choir invisible. It is an ex-car, in the words of John Cleese. That is patrimonial loss. However, damages do not only include patrimonial loss. I could hurt my neck, in which case I have a claim against the Road Accident Fund. Now, I'm not an RAF attorney. Those of you who do RAF, please correct me if I'm wrong. But one of the heads of damages is your loss of amenities of life, etc., etc. These are damages which accrue in respect of your own person, of your own body. And that is to make up for the fact that you are, as a person in your own bodily integrity, now worse off. That is excluded from a community of property estate. So please understand, mediators and attorneys, if you deal with these types of matters, there is a big difference between a patrimonial loss and a damages which relate to your person. Right. Now, eventually, given enough time in a marriage in community of property, it is almost inevitable that the spouses will start looking like this. One being extremely angry, saying, "Het jy nie gedink nie?" I won't say the swear word. And the other one saying, "Ugh." And that is because we have prohibited transactions in marriages in community of property. These were introduced by Section 15 of the Matrimonial Property Act, and we will work through them. Why do we have these prohibited transactions? Let's start with the why before we look at the what. Assume for a minute that our spouse on the left, whom I'm circling here now with my laser pointer, is liable for the debt incurred by our spouse on the right. What protection does she have? If spouse on the right takes out a loan of R500,000, spends it on drunk in the actual type of pot that we were referring to earlier, and he smokes and drinks it up, and the debtor or the creditor comes and knocks at the door of our spouse on the left, what protection does she have? Protection comes in terms of section 15.2, section 15.9, and section 16.2 of the Matrimonial Property Act. Don't worry, once again, you will get the slides, you will get a copy of the legislation. Now, under section 15 of the MPA, there are three important sections. Section 15.1 says that each party has the power to transact on behalf of the joint estate. Section 15.1, however, is qualified by 15.2 and 15.3. What does 15.2 and 15.3 deal with? Simply one word, very important word in our society, consent. Positive consent. The word positive does not appear in the legislation, but that is what it implies. Now, it distinguishes between transactions which you can do with written consent only, and there is a transaction or two that you can do with verbal consent. Section 15.2, ladies and gentlemen, deals with written consent. These transactions you cannot do without consent in writing from your spouse in community of property. Section 15.3 deals with transactions where oral consent or verbal consent is sufficient. So let's look at the wording of section 15.2. It's a bit of a mouthful. I'm going to read it very, very quickly, and then we'll go into the explanatory slides behind it. A spouse shall not, without the written consent, which I've highlighted there, of the other spouse, alienate, mortgage, burden with a servitude, or confer any other real right in any immovable property forming part of the joint estate. They shall not enter into any contract for the alienation, mortgaging, burdening with a servitude, or conferring of any other real right in immovable property forming part of the joint estate. They shall not alienate, cede, or pledge any shares, stocks, debentures, debenture bonds, insurance policies, mortgage bonds, fixed deposits, or any similar assets, or any investment on behalf of that other spouse in a financial institution forming part of the joint estate. And D, very important for the guys mediating, these are things that are emotional things. You will have to potentially be very careful in dealing with these. You cannot alienate or pledge any jewelry, coins, stamps, paintings, or any other assets forming part of the joint estate and held mainly as investments. You cannot withdraw money held in the name of the other spouse in any account in a banking institution, a building society, or a post office savings bank in the Republic of South Africa. I haven't seen a building society or a post office savings bank in quite some time, but the concept rings true. And then F, which is the most contentious one, you cannot enter into a credit agreement to which the provisions of the NCA apply as a consumer without the written consent of your spouse. However, you do not require the written consent of a spouse before incurring each successive charge under a credit facility as defined in the Act. Sure, that's a mouthful. I need to lie down now, but let's forge ahead. Let's go through them. Okay, number one, let's deal with section 15.2 A and B. We're talking about immovable property. You cannot alienate it. You cannot sell it, give it away, donate it, destroy it, etc. You cannot mortgage it. You cannot put it down as security for debt, in other words. You cannot grant a servitude over it. You cannot say, you may build a road over my property and we register that servitude at the deeds office, or lay a pipe through my property, and you cannot give anyone a real right. Now, I'm not going to go into the difference between real rights and personal rights in a lot of detail, but just for convenience, and this is a very inaccurate definition, but it helps to illustrate the point, anything that you would have to register at the deeds office, really see that as a real right. Now, outside of the lines, you will see that I've written the word contract 4 times, because that is what section B deals with, subsection B. You cannot alienate, and says subsection B, you cannot enter into a contract for the alienation. You cannot mortgage, and you cannot enter into a contract for the mortgaging. So you cannot do the physical act of mortgaging, and you cannot even sign the contract which would lead to the act without your written consent of the other spouse in the marriage in community of property. Secondly, we're going to talk about shares, stocks, etc. There was also the issue of debenture bonds, and there's a big laundry list in subsection C. Be aware you cannot alienate them, you cannot cede them, and you cannot pledge them. In other words, if you've got shares in the marriage in community of property, you flip and hold onto them unless your spouse says in writing, yes, you can sell, pledge, cede, etc. Right. Then we talk about the obvious ones, the emotional ones, coins, jewelry, stamps, paintings, or any other assets held mainly as investments. The number of times I've heard, hy sal oor my dooie liggaam die vader klaar hout kry, or ek sal vuisslaan vir my potjie, or I will kill you if you take my ring that I got from so and so. It is unfortunately something we see quite a lot, because these are emotional purchases or emotional items. So be aware that you cannot alienate or pledge these types of items. They are always tangible items. As per this one, that's why the word cede does not feature as it features in terms of the preceding paragraph in terms of shares. Now, you cannot withdraw money in your spouse's bank account without their consent. Very, very, very interesting. Then finally, you cannot conclude an agreement under the NCA, the National Credit Act, without your spouse's written consent. This includes, ladies and gentlemen, very importantly, a number of things, not just the big, but also the small. Home loans, vehicle finance, credit cards, store cards, very importantly, personal loans, etc., etc. The list can go on and on and on. You cannot conclude any credit agreement as set out in the National Credit Act without your spouse's written consent. Now, let me go back to my slides. And let's go on to section 15.3. Now, ladies and gentlemen, importantly, section 15.2, we looked at the situation of consent in writing. 15.3, we are talking just about consent. It does not say oral consent, but it does not stipulate written consent. So the consent would presumably be oral, or in some cases, I suppose, some people can argue that it could be tacit as well, but I'm not going to go into that argument. So, what can you not do without consent? You cannot alienate, pledge, or otherwise burden any furniture or other effects of a common household forming part of the joint estate. Think of the angry spouse giving away their spouse's Xbox or whiskey collection, or hunting rifles, or fishing rods, or whatever the case may be. You cannot receive any money due or accruing to your spouse in terms of remuneration, earnings, bonus, allowance, royalty, pension, gratuity by virtue of their profession, trade, business, or services rendered. You cannot receive any damages for loss of income on behalf of your spouse. You cannot receive any money due or accruing to another spouse in terms of inheritance, legacy, donation, bursary, or prize left, bequeathed, made, or awarded to the other spouse. or income derived from the separate property of another spouse. What that simply means is, let's say you inherit a property from a parent, an immovable property that is excluded by the will from the community of property estate, and that generates rental income potentially monthly. So that is what this paragraph looks at. You cannot get dividends or interests on the proceeds of shares or investments in the name of the other spouse. You cannot get the proceeds of any insurance policy or annuity in favor of the other spouse. And you cannot make a donation without value, excluding an asset of which the donation or alienation does not and probably will not unreasonably prejudice the interests of another spouse in the joint estate. Without their consent. In other words, you can make a donation. You don't have to get permission for every birthday gift that you give to someone. But if you have an investment of R1 million and quickly before you get divorced, you donate that R1 million to your brother, the court will probably raise an eyebrow or two and ask you to please explain kindly, Mr. or Mrs. Spouse. Right. So let's go through our pictures. Furniture or household effects, you cannot alienate, pledge, or burden. You cannot, in a marriage in community of property, receive money accruing to the other spouse in terms of remuneration, damages for loss of income, inheritance, donation, bursary, etc., income derived from separate property, dividends, or proceeds of an insurance policy or an annuity without their consent. Nice little cheat sheet that you can print out and utilize. And then finally, you cannot make a donation without value. Now, the question arises, but he's not allowed to, but he did. But she's not allowed to, but she did. What happens? What can you do? And there, let's look at the remedies available to our aggrieved spouse. And for purposes of this particular discussion, we are going to accept that John, on the right-hand side, entered into some naughty transactions, and Jane is ready to swing some fists at him because she is now liable for half. Now, guys, there are two types of relief available. The first is in terms of Section 15(9)(b) of the Matrimonial Property Act. And the second is in terms of Section 16(2). Now, what I want to show you, and I'm going to skip a slide and I'm going to go back one slide, is there are two types of relief. You get your adjustment in terms of Section 15(9), which is retroactive relief. I've highlighted here, and I just want to see mine. Yes, it is there. Good. And then we have our suspension of powers, which I also like to call the dog without teeth in some instances. I'll tell you why later on, which is our proactive relief. So be aware that there are two different types of relief. Now, what does an adjustment entail? Okay, Section 15(9), if you want to see a nice vague section in the Matrimonial Property Act, look at Sections 15(9). So when a spouse enters into a transaction with a person contrary to the provisions of Section 2, subsection 2 or 3, remember, no consent in writing, no consent verbally. Those are the two we dealt with. That's subsection 2 or 3. Or an order under Section 16, which we'll look at a little bit later. And look at now at subsection B. That spouse knows or ought reasonably to know. It's very, very vague in my opinion. That he will probably not obtain the consent required in terms of subsection 2 or 3, or that the power concerned has been suspended, which is our 16(2), and the joint estate suffers a loss as a result of the transaction, an adjustment shall be effected in favor of the other spouse upon division of the joint estate. Okay, now let's look at our requirements for an adjustment. Firstly, question 1, when does a adjustment claim come in? Ladies and gentlemen, just a reminder, if you have any questions, please type them in the comment box. And Shantae will field them. We will be taking verbal questions a little bit later. What are our requirements? When can this take place? And what is the nature of it? Our Section 15(9) adjustment. Firstly, be aware that your Section 15(9) adjustment must take place upon divorce. Why? Because you're talking about division of the joint estate. And I'm highlighting it there on the screen. Division of the joint estate. You cannot have a division of the joint estate without a divorce. Because if there is no divorce, you divide the joint estate, but you're still married in community of property, so it all goes back into the joint estate. Notable exception, obviously, is a change of matrimonial property regime, but we're not going to deal with that in this 101 and 102 course. Today, we might look at it in another session. Now, we've established that your Section 15(9), i.e. your adjustment to say my spouse has been naughty, they did a transaction that they were not supposed to, I must therefore get more out, there must be an adjustment of the division in my favor. That takes place upon divorce and division of the joint estate. There is authority. Be aware of this. If anyone wants the authority, please do message me and I'll send it to you, but I didn't want to convolute this session to suggest that your order for adjustment must be made simultaneously with your decree of divorce. You cannot get an adjustment without the court having ordered it first. So now we know when it takes place. How does it take place? What do you need to prove? Well, you need to prove that the naughty spouse knows or ought reasonably to have known that they will probably not get the consent of the other spouse. It's a difficult one to prove, but there are facta probanda and facta probantia that we can look at in terms of how do we go about proving this. For example, let's say divorce summons was just issued and the spouse receives it and then out of spite quickly goes to a bank, falsely discloses that they are single. The bank doesn't pick up that they're married in community of property, take R1 million loan out of spite. What are the chances that their spouse would have consented to that? I would say there's much more of a possibility that I would get pregnant than the other spouse consenting to that transaction at that stage. So you look at the circumstances surrounding. Whereas, let's say the spouse was naughty, but during the course of the marriage, it became practice. The parties didn't know what their rights and responsibility were. Mom would go and get a loan here to pay for renovations. Dad would go and get a loan there and pay school fees in advance, etc., etc. Then you might be naughty, but how were they to know that now all of a sudden it would be a problem? It was always accepted up to that point. Folks, I see I've got a bit of bad network quality. I'm just going to hang back until it stabilizes so that we don't miss any of the content. Can I just check, Shantae, can you confirm, can you hear me properly? Before I go on and there's the risk of content going missing. Everything good?
I can hear you, Mervyn.
Fantastic. Thank you very much. Okay. So test number one is the spouse knows or ought reasonably to know that they will probably not obtain consent. Once you've proven that, there is still a second leg that you need to go through, and that is that the joint estate suffers a loss. Now, what is that loss? And I had a matter years back where I was dealing with a particularly naughty spouse on the other side who had incurred near to 2 million rands worth of debt for the joint estate and had sold shares of nearly R1 million, kept the proceeds for themselves and it became a huge fight in that matter. How do you calculate the loss? For example, they incurred debt in respect of a property which they sold without my client's consent. So number one, they sold the property. The proceeds were about 50,000. So where is the 50,000? If that 50,000 is gone, the joint estate has suffered a loss. And my client would then have been entitled to 50,000 divided by 2 because it's half joint estate. So my client was entitled to an adjustment of 25. However, to sell that property, he took bridging finance to pay off the arrears because he hadn't been paying his levies and municipal and. So that was a loan of 20,000 Rand, which accrued interest of 1,500 Rand during the course of the transaction. So there is a further adjustment in terms of that further loss, which came out of the proceeds, etc., etc. So be aware that you need to prove a loss. Let's talk about scenarios where you don't suffer a loss. Okay, simple. I go without my wife's consent. I'm married in community of property. Thank goodness I'm not. But supposing I was, take a loan of 3 million Rand. The joint estate now suffers a loss. However, Standard Bank, Nedbank, microlender, whomever the case may be, are lax in recovering it. My wife finds out on the first day of year 4 after I fell into default. She says, but you bugger, why did you do this? We've suffered a loss. I can turn around and say, no, actually not. That debt has prescribed. So I was naughty, but that debt is now unenforceable. Remember, ladies and gentlemen, civil debt in South Africa prescribes after 3 years. So if a creditor does not enforce it within that time, it prescribes, it becomes unenforceable. All of a sudden, yes, I knew, or I ought reasonably to have known, that I would not get the consent. Yes, I did the transaction anyway, but now the debt has prescribed. So I took the money, I used the money, but is my spouse actually going to suffer loss? No, they are not, because of that prescription. Okay, so that is our first relief. A bit of a mouthful, but we'll forge ahead and we'll debate it later on if anyone is uncertain. So remember, our adjustment over here is our retroactive relief. In other words, the horse has already bolted. Die koel is deur die kerk. What will be, will be. And all of those other lovely platitudes. Then we get proactive relief, suspension of powers. Now, what happens in a suspension of powers is the following. This I'm going to read from there where I'm scribbling with my pen. If a court is satisfied that it is essential for the protection of the interests of a spouse in the joint estate, it may, upon the application of that spouse, suspend for a definite or an indefinite period any power which the other spouse may exercise under this chapter. In other words, you suspend your spouse's power to transact on behalf of the joint estate. Okay? Now, how does that work? You go to court, you say, listen, my spouse is running around all and sundry, incurring debt. I'm going to be liable for half. There is a problem somehow at the deeds office. They were married previously. They are listed on all the credit bureaus as married out of community of property. They are capitalizing on this. The banks aren't picking it up, and they are incurring debt. If the banks find out about this, I am in SH1T, which I won't pronounce because this is being recorded for the interwebs. So, what happens in that scenario? If the bank finds out, they can hold both spouses liable. Why would you want to chase one debtor when you can chase two? I made the joke with some of my attendees earlier. The difference between an attorney and a mediator is an attorney just chases one client. They have to chase two. But that's what the banks effectively prefer to do, or any credit provider. Why chase one debtor and see what's behind door number one when you can, for the same price to issue a summons, chase debtor number two as well and see what they have. One to pay, the other to be absolved. So then you can say to the court, they are racking up this debt. It is essential for my protection. Here are 10 letters written by my attorney saying, please give us a written undertaking under oath that you will not do this. And they've refused to do it. Or they've given us this undertaking last year in April. Incidentally, what happened in a matter of mine, the attorney gave this undertaking, here it is. But we found out 2 weeks after that, he bought a brand new car on credit from a luxury car dealership. How can I trust this undertaking? His powers or her powers must be suspended. The court can then suspend their powers. Now, how do you enforce that? That becomes problematic. If you are proactive, you can obviously go to each credit institution and you can say to them, listen, we now inform you that their powers have been suspended, give them credit at their own peril. How many credit providers are there in the Republic, however? So there we deal with subsection 9A and B. Again, look up there. If an order under section 16 has been granted and you are still naughty for some reason, there will be an adjustment. Is it a perfect remedy? No, it's not a perfect remedy. Let's say you caused 2 million rands worth of damage and the joint estate is only worth 500K. How do you deal with it? I hope you have a sharp liquidator in those cases. So be aware, if you are married, this is a very interesting question. I actually want to stop on this. Rickma, could legal fees incurred by one spouse to suspend powers with a guilty spouse be eligible for adjustment? I don't think so. You would be able to get an order for costs in court against the guilty spouse. That's what happened in the case that I dealt with. But remember, each party has the right to spend money in their account which they earned as they see fit. So it becomes a question of litigation, but very, very interesting conceptual question. I would say conceptually, you know, if you actually just debate it in your head, probably not a bad idea. Rickma, if you find any authority, please share with me and I'll share with you if I find as well. Unfortunately, folks, there is a dearth of case law on section 16.2. There's not much going on in terms of cases. That which there is unreported and you really have to go digging for it. Incidentally, conceptually, and thank you for the question, Rickma, a section 16.2 adjustment does not have to go coupled with a divorce. You can do it at any time. It's quite unlikely that the marriage will survive one spouse saying to the other spouse that I am suspending your powers, you naughty boy or you naughty girl, and I don't trust you to transact on behalf of the joint estate. And then obviously the trust is broken. I've got Teresa, one of my physical attendees. Yes, what do you want? Would you like to ask?
No, just a comment. Saw one many, many years ago connected to mental illness. Didn't want to divorce his wife. He didn't want to leave her.
Yeah.
He didn't want to declare her unfit. He just suspended.
Wow, that's interesting. Tell me, very interesting. Teresa sharing with us a case that she dealt with during her articles where there was a case of mental illness and the termination based on that. Very, very, very interesting. Very interesting. Stella, question from you.
Thank you, Mervyn. So if there was no consent by spouse 2, when spouse 1 applied for credit,
Yeah.
would the creditor still then have recourse to go after spouse 2?
There is authority to suggest that if the creditor knew that there was a marriage in community of property, it would render the credit agreement unlawful. If they knew. But if they didn't know, then spouse 2 is fair game, and that's where this adjustment comes from. It's a joint estate. Remember, every single asset, every single debt, the minute you incur it, falls into that pot in the middle. So I'll share with the group, for those who are interested, the case law that I do have, that I have dealt with in this regard, where a credit provider was a bit naughty and they knew that there was a marriage in community of property and they gave the debt anyway, versus the situation of an innocent in inverted commas credit provider. Right. So let's move on. Let me just get my mouse cursor where it should be. Now, we're going to have a nice palette cleanser and we're making fairly good time. We're about halfway through the course material by my estimation. So we are making fairly decent time and we've probably got about 15 minutes for a quick Q&A and for some discussion and debate in this regard. But let's have a palette cleanser. After that complexity, let's talk about marriages out of community of property. What's mine is mine. What's yours is yours. The end. Right. No, not always. Not always. What happens in Vegas goes to the doctor's office, Teresa, incidentally. Right. So let's quickly talk about marriages out of community of property without the accrual. I've only got one slide. It is very, very simple, but there are one or two things which you do need to know. Let's look at our three characteristics, which I'm going to draw on the screen here again. It's a non-default position. Be aware of this. You need an anti-nuptial contract. Folks, remember the term anti-nuptial. Anti means before. Nuptial means your wedding, your marriage. You have to have the contract in place, notarized before the marriage and registered within, I think it's, Chantal, correct me if I'm wrong, I think it's 3 months thereafter or 2 months thereafter. I'm not a notary, nor do I intend to do notarial practice. You can change the position, but you need leave from the court. So understand it is an anti-nuptial contract that you need to enter into to be married out of community of property without the accrual. You need to specify furthermore in that anti-nuptial contract that there will be no accrual. It is a non-default position. You need an anti-nuptial contract. Number one, you need to specify that there will be no accrual. If you have an anti-nuptial contract and you don't specify that there will be no accrual, you are married with the accrual. Now, there is independent administration of separate estates. You are the sole administrator of your estate. You can do with it what you like. You can piddle it out against the wall. You can donate it to your neighbor. You can set it on fire if you like. You can do whatever you want to do with your estate when you are married without the accrual, because your spouse at the end of the day has no interest in your estate. Good luck going for a spousal maintenance claim if you burn all of your assets, however. There is no community of property. Each party's assets and liabilities form part of their own separate estates. Neither party has any claim to the assets of the other, nor the parties liable for the debts incurred by the other. And that is why the sole administration, just to drive home the point, comes in, because you are the sole owner and holder of your estate. Okay. Very important, folks. A marriage out of community of property does not preclude spouses from buying assets together. It should follow, but I put it in for completeness. I could buy a property together with Stella here, or with my assistant Quinn, or God help me, with Teresa, even though there is no marriage, but it still follows. Sorry, Teresa, I must pick on you. So you can still buy assets together, even though you're married, without the accrual out of community of property. There is also, and this is a very, very interesting point, which I dealt with a few years back in a case. You can, even if you are married out of community of property with no accrual, allege and prove a universal partnership. So you can say, we are married out of community of property, no accrual, but we purchased this property only in my spouse's name because I was not creditworthy, but we had an underlying agreement that it would be an investment property. I renovated the property. I added something to the universal partnership. And don't worry about all of these terms. We'll deal with universal partnership. No. But I put things in, they put things in. I must still get 50% value from the dissolution of that partnership, even though there was a marriage out of community of property, which is very, very, very interesting. And this is from the High Court in Gauteng. I think, yeah, that is the Gauteng Pretoria division, throwing a spanner in the works, and not my hometown of Johannesburg. Right. Before we go into our question and answer, I would like to draw your attention to this webinar that is coming up in 2 weeks' time on the 18th of February from 9:30 till 12:30. This is actually going to be taking the form of a panel discussion. And if you would like to register, please take out your cell phone now. Simply switch on your camera and point it at the QR code which you see on the right. It will take you to the registration page. People are looking at me incredulously. Try it. I promise you it works. I'm very excited about this one. If you will indulge me, just the shameless plug, I've got a panel of 3 people joining me for that discussion. Sunay Schwim, who is a practicing attorney, who also works with a company called Wealth Succession. They do estate planning and trust management for high and ultra high net worth clients. She is very, very knowledgeable on the topic. I've asked our own Stoutgat Teresa Light to come and join me for the simple reason that she is a CFP who is also a mediator and also deals with a lot of estate planning within her mediations. I see someone mentioned they are watching on their cell phone. No problem at all. I will send you the link to register to the webinar after this session, so please do not fret. Right, and then finally, I have asked Jacques Tron. He is a Sanlam financial advisor. He is also one of the organizers of the Business of Business conference annually, to join us from a financial advisor's point of view. This webinar is only via Teams. It is not a hybrid like the one today, and it is a free webinar. We're going to be discussing the basic principles of estate planning. What is it? How does it work? We're going to look at collaborative estate planning in divorce, specifically for mediators. How do you make sure that your divorce settlement works for both parties given their financial constraints, considering policies that can be taken out and insurance products that can be utilized. We're going to look at pension funds in divorce, which is always a very, very interesting topic. We're going to be looking at trusts and divorce and piercing the trust veneer for alter ego trusts and sham trusts. We're going to be looking at last wills and testaments in divorce, and we're also going to be looking at frequently encountered pitfalls. Please do have a look at registering for this if it is something which you feel may benefit you in your practice. Then I would like to, before we go into the Q&A, just invite you again. You can scan my business card there at the top. We can connect on LinkedIn. Also, there are my personal details. This is now basically the end of session 1, after which we're going to do a quick Q&A and a comfort break, and then we will go into session 2, where we're going to be dealing with accrual, we're going to be dealing with forfeiture, and we are going to be dealing with universal partnerships. Just before we go into our Q&A, I do want to mention to those of you who are mental health practitioners and mediators, I did not put a link on the screen for this. Please use the comment box to indicate if you are interested. I have created what's known as an Ask an Attorney group on WhatsApp. It is a free group which is moderated by myself and my team in Johannesburg, and also thank you to Rikma and her staff who are also on there. They're based in Cape Town, also family lawyers. Thank you also for their input on that group. It is specifically for mediators, mental health practitioners, if they have a quick legal question, just to run something by, just to get some assistance and some debate on legal questions. If you are interested in joining this group, please just indicate in the chat box, and we would be happy, if you are a mediator or a mental health practitioner, to add you to the group to assist you in your practice. Right, so it is now 10:32. My suggestion is that we do 15 minutes of Q&A. Whereafter, perhaps let's take a break for 15 minutes until 11, and then we do our final session. Everyone good with that? Any questions? Fantastic. Great. Let's go. Shantae, can I draw you in over here? You're welcome to switch your camera on so everyone can see what you look like as well. I'm going to have them ask you all the difficult questions. You there?
I'm here.
Excellent. Any notable questions that have come up during the first session that you would like to debate so long?
Yes, I think there was one that came through from Rikma, where she asked regarding could legal fees incurred by one spouse to suspend the powers of the guilty spouse be eligible for adjustment. So I did give her an answer to say that should a court usually be approached, the court would make an appropriate cost order. I don't know if we maybe should just take that a little bit further.
Absolutely. Look, yeah, I think Rikma's question was with regards to that loss. Does it include the loss of the legal fees incurred on behalf of the joint estate? Now, in my matter, which I dealt with, we chewed on this quite substantially. I was working with Vermeulen SC on the matter, and we decided not to try and incorporate the legal costs in the adjustment claim, but we did certainly ask for attorney and client costs against the offending party. What had happened there was it was shortly after divorce summons was issued and served. The other side, upon us throwing our toys out the cot with regards to a contravention of the MPA, gave an unequivocal undertaking on their letterhead that their client would not further prejudice the joint estate by his actions, and he then went and incurred just over R1 million worth of debt and got rid of assets. And when we found that out, when we issued subpoenas, we then had to launch the Section 16(2) application. All right, I've got a question here. Gifts. What happens with gifts? Well, simply gifts are generally, if you look at the Matrimonial Property Act, for your marriages with accrual, gifts are specifically excluded from the accrual calculation. Right. There's conflicting authority on the issue of wedding rings and engagement rings. We'll deal with that one after the break. Let me just have a question. Well, let me just have a sip of water before we get there. Neil, it's good to see you in here as well. You've been very quiet, enforced quietness. How are you doing? You well?
Find yourself, Mervyn.
Good, man. Lekker. Good to see you here. Guys, anyone else who have any questions, please use the raise hand function. We've got 10 minutes for Q&A. Okay, I've got Stella here. Stella, I'm just going to point the mic towards you. Please speak up.
Thank you, Mervyn. I just want to know for the adjustment, say for in the scenario where maybe shares was sold 10 years ago and the value was $500,000, but now at the time of the divorce, it's worth double. What amount do you use for the adjustment?
I'm not aware of any authority that would suggest the manner in which you would do it. Obviously, the aggrieved party would say that the share value as at today's date must be taken into account. The naughty spouse will obviously say that it must be as at that date. The damage will also obviously depend on what they utilized it for. They could say, well, I sold these shares and I was naughty, but I actually used half of the money to put in our swimming pool. And I just pretended to be Mr. or Mrs. Moneybags. Meanwhile, I'd sold my shares to be able to do this. And that actually increased the value. So how these things usually work is you would have the adjustment ordered by the court together with the order for division of the joint estate. So the court order would look something like this. A decree of divorce. 2, division of the joint estate. 3, an adjustment shall be effected upon division of the joint estate in favor of the, let's say, plaintiff, for example, in respect of the damage caused to the joint estate by XYZ transaction to be calculated by the liquidator and receiver to be appointed, for example. You can have a judge who can say, well, let's actually do the calc now. I think it's unlikely, though. I think they'll kick it out to a liquidator and receiver. And the liquidator would then have to, or the referee, as they're called, would have to come in and actually do the L&D and effect the adjustment. Yes?
And then you build a liquidator.
Well,
Don't agree with that value.
you'd have to, yeah. That's another story. That's another story. You know, some people will never stop litigating. Right. Any of our online folks have any questions which they would like to raise? Please use the raise hand function. Please don't be shy. This is a safe space. Remember, if anyone is nasty to you about your question, even me, they'll get kicked off. Okay. Excellent. Right, folks, thank you so much. We're going to take a quick break for 15 minutes. It's now 22:11. Can I suggest that we reconvene at 5 minutes to 11? And then we will forge ahead with our second session, which is going to be marriages with the accrual, universal partnerships, and forfeiture claims. Thank you so much for the feedback, Emma. I appreciate it. I'm going to leave this slide on. Those of you who would like to test out your technology in the break, see if you can find my business card or connect with me on LinkedIn. Please feel free to do so. Thank you so much, guys. I'll see you again in 15 minutes time. For the questions, let's go into the real meat of this presentation. Let's talk about marriages out of community of property with the accrual. Now, folks, as I mentioned to you earlier, and if you will recall, a marriage out of community of property with the accrual is one where there is deferred sharing of gains. Now, remember these 4 words: deferred sharing of gains. Let's talk about what a marriage in community of property versus out of community versus accrual is, and not what they are not. In terms of accrual, let's talk about what it is. It's deferred sharing of gains. What is it not? It is not a communal pot in the middle. It is not a completely separate with no sharing. It is deferred sharing of gains. And how are those gains shared? Usually in cash, money, cold, hard, cash, contant, moolah, dosh. Not generally in terms of asset sharing. Can you utilize assets to satisfy an accrual claim in a settlement agreement? Absolutely, you can. But you cannot say, well, I have this old Ford Cortina and it is worth 30,000 Rand and your accrual claim is 40,000 Rand. So here's a Cortina, I don't owe you anything. The other spouse could say, I don't want the bloody Cortina. Then you have to sell the Ford Cortina. And some of you are old enough to remember Ford Cortinas and the fun we used to have with them. Right. So remember, it is deferred sharing of gains, and it is generally in terms of a cash payment. How is accrual calculated? What is it? How does it work? Okay, let's go through the characteristics. Then we are going to talk about this final point here, accrual sharing, which seems like a mouthful in terms of the wording of the act. It is a bit of a mouthful in terms of explanation. I'm going to try my best. Please do not have me shot at dawn. If you still have trouble, rather just connect with me, pop me a mail and say, sure, I still don't really understand this. Please, can we talk? And I'd be happy to assist you. Okay. Factor number 1 of a marriage out of community of property with accrual, and the most important one, understand it because this is a huge misconception. There is no community of property. Each party conducts their own separate estate during the course of the marriage. There is no community of property unless, obviously, you buy an asset together, in which case you deal with the actio communio dividendo. If you need to divide it, then it is a jointly owned asset and not necessarily a joint estate. Neither party has any claim to the assets of the other, nor are the parties liable for the debts incurred by the other. You have your own pot. Remember, let's talk about pots. You look at your 2 people over here. If I can just go back 1 slide. We are talking about pots. The lady on the left has her pots. The gentleman on the right has his pots. Jane has her pots. John has his pots. What are we concerned with in terms of the accrual? My pot has grown, yours has not. Let's consider this. two people go to a potjie cook-off and they each bring their own potjie. And party number one says, listen, I am going to stay here and I'm going to make sure no one runs off with our potjie. You go out and you go get ingredients. So party number two runs off and gets ingredients. All of a sudden, party number two's pot is this big. Party number one's pot is this big. Is it fair? No. That's where community of property with accrual sharing came in. Let's look at the historical context, ladies and gentlemen. It was 1984 that this concept of accrual really came into our law in terms of the Matrimonial Property Act 88 of 1984. It was the same legislation that abolished the marital power, where all of a sudden men and women were placed on equal footing, and it's as if the society at that stage and the legislator all of a sudden realized out of nowhere that women are people and they have rights that need to be protected. Can you believe it? And why I refer to women is that is the society that was there. If you even look at the case law, they talk about dad being the breadwinner, mom being at home. And it was to facilitate a position where you would have a sharing of the gains with the understanding that one spouse would generally be enabled to build their estate because the other spouse presumably looked after kids and managed the household. Ironically, most of my divorces these days, the higher accruals go to the ladies, as controversial as a statement as that may be. So good on you, ladies, and hopefully we'll be able to keep up on behalf of my agenda. So independent administration of separate estates is something that we must remember forms part of an accrual marriage. Each party is the sole administrator of their estate, and it is unfettered. You can do any transaction you want, provided that it is in good faith. You have a responsibility. There is SCA authority for the point that you have a responsibility between spouses married with the accrual uberime fidei, i.e. of the highest echelons of good faith, to not conduct yourself in a way to impoverish your estate or fictitiously impoverish your estate to frustrate an accrual claim. The good example of this will be someone who just received a divorce summons and all of a sudden they donate 2 million rand into a trust and they are the sole trustee and beneficiary, and now they say, well, it's not part of my estate anymore. Okay. It is a non-default position, but it is the default non-default position, if that even makes sense. And why I say that is this: you need an anti-nuptial contract, yes. However, if you do not stipulate that there will be no accrual sharing, that you just exclude marriage in community of property, then you will be married in terms of the accrual. Okay, now, I was avoiding this and I was scared of this, but let's get into it and slog through it together. Let's go through this ordeal. What is accrual sharing? Section 3.1 of the MPA says, at the dissolution of the marriage, subject to the accrual system by divorce or by the death of one or both of the spouses, the spouse whose estate shows no accrual or a smaller accrual than the estate of the other spouse, or his estate, if he is deceased, acquires a claim against the other spouse or his estate for an amount equal to half of the difference between the accrual of the respective estates of the spouses. Now, what's interesting, folks, I mentioned to you earlier, consider the history. Look at the wording. No accrual acquires no estate, or his estate, if he is deceased, acquires a claim against the other spouse or his estate for an amount equals half the difference. Interesting historical factoid. Not their estate or her or his estate, as we see legislation now. We have moved on a bit as a society, thank goodness. So what does this mean in practice, folks? Let's talk about the practical implications. Let's talk some calculus. Let's talk some mathematics. Okay, Section 4 of the MPA is your Bible when it comes to this, as read with your anti-nuptial contract. The accrual of the estate of a spouse is the amount by which the net value of their estate, and I'm going to replace the his with their. Legislation might not be up to date, but I am myself. So their estate at the dissolution of the marriage exceeds the net value of their estate at the commencement of the marriage. In the determination of the accrual of a spouse, any amount which accrued to them by way of damages is left out of account. We'll talk about that later. An asset which has been excluded from the accrual by virtue of the ANC, as well as any other asset which he acquired by virtue of the possession of the former asset, is not taken into account as part of that estate at the commencement or the dissolution of the marriage. Sure, that's a mouthful, but we'll slog through it. The net value of that estate at the commencement of the marriage is calculated with due allowance for any difference which may exist in the value of money. And for that purpose, the weighted average of the consumer price index serves as prima facie proof of any change in the value of money. The accrual of the estate of a deceased spouse is determined before effect is given to any testamentary disposition, etc. In other words, divide the accrual first, and then the beneficiaries can come to the. I've got this picture of lions at a carcass eating, and I think it's a bit dark as a metaphor, but as macabre as it is, that really is the case. First, the accrual claim, you eat, then you go, and then the rest come in. Okay. Now, how do you calculate an accrual? Right. 4 steps. Number 1, you ascertain the commencement values. Ladies and gentlemen, this is the easiest thing to do. Even attorneys can do it. You look at the ANC. Usually around about page 2 or 3, you will see the parties herewith declare that for purposes of calculating their accrual, their commencement values shall be blip, blip. If they do not stipulate a commencement value, this is a very important, frequently asked question, even for the attorneys out there. If there is no stipulated value and they never did a statement of their assets after the signature of the anti-nuptial contract, it is deemed to be null. And that's not me saying that, it's the Matrimonial Property Act, section 6(4)(b). So, mediators, attorneys, if you ever get an ANC and there is no stipulated commencement value, assume null. Right. Then, folks, what you do, Neil, can I ask just for purpose of this, if you can just type in the comment box, we'll do verbal questions after the session. Thanks, mate. Sorry, man. You then take the commencement value and you adjust it by the weighted average of the consumer price index. Section 4(1)(b)(3). That is probably the most difficult part of doing an accrual calculation. But lucky for you, I'll show you guys how to do it. Easy peasy. Right. This this weighted average of the consumer price index, I will be sharing the table with everything from Jare Tut up to December 2021 with all of the attendees after the session. It is generally kept by Stats SA, who are, for those who are interested to know, at least that's where you can find it online, the easiest. Just type in Stats SA, Consumer Price Index Table Weighted Average. Okay, then once you have ascertained the commencement value, now you go on to the second leg, and you have to then calculate, what am I worth now? That takes a calculation of net asset value. What are your assets minus your liabilities? What are you worth now? But before you can get there, you go to step 2. You disregard excluded assets. So you're going to say to your client, whether it's someone who's using you as their attorney or whether it is a party to mediation, give me a copy of your ANC. Give me your balance sheet as it stands now. Look at your assets and liabilities. If an asset is excluded in the ANC, section 41B2, remember our mouthful earlier, you delete it, you forget about it, you chuck it in the garbage as we see in the picture in the back. If you have a Ford Fiesta today that you bought with the proceeds of your Volkswagen Golf, which was excluded by the ANC, guess what? The Ford Fiesta is excluded. However, you have to now unscramble an egg. What if you sold the Volkswagen for 50,000? You bought the Ford for 60,000. You put 10,000 in. What portion is excluded, included, and it becomes a very, very problematic thing in terms of excluded assets. Shantae, in fact, is busy with a matter now where our client is a property developer who had one access bond on one property of 3 million, which he has now turned into 3 petrol stations, 5 properties, and a trust with a list of beneficiaries yay long, of which the other side are trying to pierce the trust veneer. How do you take back each of those which the client alleges are excluded because they came from that one asset? Imagine to yourselves that digging expedition and say, thank you, thank you, thank you, that I am not an accountant or an auditor or an actuary. Yo, that's a big job. Right. Then we talk about damages, section 41B2. Now remember, folks, I explained to you earlier patrimonial and non-patrimonial loss. Patrimonial loss is the car being written off. Non-patrimonial loss is the damage to your neck. Patrimonial loss, if you got a damages claim, let's say you had a car worth 50,000, it's now written off. You get a damages claim to replace the car. It was an asset, it was no more an asset, now it's an asset again. That is not excluded. What is excluded is the pain and suffering you got from the RAF for your neck. That is excluded because it accrues to your person. Inheritances, legacies, and donations, section 5(1) are excluded, specifically excluded. Specifically also section 5(2), donations between spouses, excluded. I've got a matter now where my client is very angry at himself because he gave his wife a few months before the divorce a gift of a few million rand. Now she's saying, well, that's not part of the accrual, and she's right. So disregard your excluded assets. Then you calculate the dissolution value. What your commencement value is in the ANC, or it's null. Your dissolution value you get from your client. Give me your assets, give me your liabilities with supporting documents. Total asset value minus total liability value equals net asset value. Then you take your net asset value at dissolution and subtract your adjusted commencement value. And that is your accrual. So, how does an accrual calculation look? Okay, let's talk about John and Jane. John and Jane got married in November of 2015. At the commencement of the marriage, John is at the top, Jane is at the bottom. The marriage date is here on the left-hand side. Divorce date, March 2019, is on the right-hand side. Okay, this is based on a calculation I had to do a few years back. Names changed, amounts changed, dates kept the same. Okay, now, John was at time of marriage worth 100,000 rand. Or so he said in his anti-nuptial contract. He stipulated that he's worth 100,000. Jane said she was worth 600,000. Both of them signed. Caveat scriptor means that if you sign something, unless you have very compelling reasons, you need to read what you signed because you are kept to it and it is accepted that you understood what you signed. So he was worth 100,000, she was worth 600,000. Then on honeymoon, round about here in December 2015, sitting on the beach, John says to his dear wife, Jane, you know what, my dear wife, I want to go into venture capital. So I suggest that you take your 600,000 Rand and you conduct yourself in a stable job. Go get a job, work for a salary. If the pawpaw hits the fan with my investments, we know we are okay. Jane says, yes, why not? Jane gets a job. She's a salary earner. She conducts most of the household. And at the date of dissolution of the marriage, they get divorced in March 2019, she is worth 2 million Rand. John's investments paid off. Boy, oh boy, did they pay off. He is worth 10 million Rand at date of dissolution of the marriage. Now, you can see John looks very, very frustrated as he is standing there, and I'll show you why now. He is about to pay his ex-wife a lot of money, the poor thing. But, shame, caveat scriptor, as they say. This is the calculation. I'm going to share this calculation with all of you who don't have the capacity to read as fine as it is on the page, but we will work through it briefly. What it comes down to after we go through the accrual calculation is that John accrued 4.59 million Rand more than Jane. John's accrual is 9.8 million. Jane's accrual is 5.292 million. So John has to make payment to Jane, and I want to show you guys the net upshot before we do the calculation so you understand the conceptual basis behind it. Now remember, she has a claim in money against John, not in terms of liquidation of joint assets. There are no joint assets unless they bought them as co-purchasers. There is no joint estate. So she has a claim in money against him. And that claim in money will be 2,295,000 Rand. Why do I say that? It's half of this amount. That's what the law says. So an amount equal to half the difference between their accruals. Now, saying that is a mouthful, and conceptually that is difficult to understand. But see what happens, then it will make sense. So he's worth 9.8 now. She's worth 5.2. He is worth 4.5 million more than her. What happens if he pays her half the difference? This. She's worth 7.587 million. He is worth 7.587 million in terms of their accrual claim. Okay, now let's go to how we do the calculation. The sheet will be shared with you. I'm not an accountant. It is probably not perfect, but it is going to get you close as damn it to a swear word to what the actual accrual is to the cent. Okay, now what you need to calculate the accrual, if we look at our previous slide, and I hope everyone can see, let's just work on Jane Doe's accrual over here. You need to know, firstly, from your client. You're not seeing the pen. Let's see there. Oh, they're not going there. Oh, no, man. That's a pity. Okay, folks, please just bear with me. Let me just quickly get my pen over here, or let me just use my mouse so that I don't waste your time. Okay, where is my pen over here? So if you look on the left-hand side, I'm like scribbling furiously. Thanks, Kyra, for telling me now an hour exposed factor. Right. You need a few things. Firstly, you need the date of the anti-nuptial contract. Secondly, you need the date of the calculation of the accrual. Then you need the commencement value of the party. Now remember, you see two pieces of paper here. On the left-hand side, we've got Jane. On the right-hand side, we've got John. Why? Because each of them is going to have their own calculation of the accrual. Okay? So you need to know what's her commencement value. Where do we find it? In the anti-nuptial contract. Or the MPA makes provision for them to sign a sworn notarized statement or notarized statement of what their assets and liabilities are. If you, or their commencement value, apologies, the commencement value is. If you don't find that, you assume null commencement value. Welcome back, Quinn. Then you need your adjusted commencement value, which we're going to do over here. Okay. Then you need your net asset value. Okay. Now let's go through these things one by one. Date of the anti-nuptial contract. Very simple. You look at the date of signature of the anti-nuptial contract. Date of calculation of the accrual. You look at the date where you are now. Generally, it will be date of decree of divorce. But if you're doing it in a mediation setting, you're not going to be at divorce yet, but sure, but it's going to be very illustrative of the position. Then you look at the commencement value. Look at the ANC, look at the notarized or the sworn statement. If you don't find it, assume null. Now we have to go into the adjusted commencement value, which is where we take this 600,000 and we account for the difference in the value of money between 2015 and 2019. So for purposes of illustration, and here's the calc, I'll show you now how this calc works. 600,000 Rand in 2015 is 708,000 Rand in 2019. So to get 600,000 2015 value, 2019, you need 708,000. It's a sobering thought, isn't it? And then you need the net asset value. Now, I haven't put this in because most of you should know how to do this. You do a statement of assets and liabilities. Assets at the top, list each asset with its value and why you say it's that value. Liabilities at the bottom, amount of each liability, name of each liability, and why you say that's the amount. And you subtract the two from one another. So let's say, for example, Jane had 7 million Rand in assets, 1 million Rand in liabilities, so her net asset value is 6 million Rand. Okay, those are the figures that we need. So let's circle back to how we calculate the adjusted commencement value. Okay, now what I'm going to do is I'm going to share the CPI table with you because you're going to look at let me just quickly go here. My apologies. So here is the CPI table as at December 2021, which I'm going to screen share with you now. Don't shout at me yet, guys. Almost there, almost there, almost there. There it is. Okay. This is what it looks like. It gives you a figure per month for each month of the year in a particular year. Then it gives you the average at the end. So for 1980, the nominal value of money was 4.0. The average for the year, or in January 1980, December 1980, it's 4.7. So your weighted average for the year is 4.3 over there. Okay. So now we go up to 2017, for example, and your weighted average is 103. Not seeing. Oh no, oh sure, but I'm sharing on the wrong screen. Okay, let's go over there. Thank you. One of the hazards of working in a hybrid setting. Okay, there we go. Now everyone can see, hopefully. So what does this table tell us? 4.30 Rand in 1980 is 92 Rand in 2015, is 121 Rand in 2021. Okay. So what are you going to do? How do you do this calculation? So this table I will share with you guys. You can get it on Stats SA website. And the figures that I'm going to work on this accrual calc, let me just close over there. And let me share my screen with you again. These figures over here, if you see the figure of 93.4 and 111 over there, that is from that table. So what we need to figure out, ladies and gentlemen, is to take this 600,000, which is the commencement value, and we must multiply it by something. to see what the amount is now. So you don't have to understand it, just do it. You take your CPI figures at your two dates. You divide the one by the other one. So you take March 2019, which is 111. You put that first. Then you take November 2015, and this is now for the actual year. I didn't work on the averages here. You can work on the averages in general. 93.4. You punch that into your calculator. 111 divided by 93.4 equals, then your calculator will kick out this. Then you can just adjust it to 2 decimal values, which I like to do because we are going for ballparks. We're not liquidators and receivers. We want a ballpark, okay? Then you're going to say, okay, I'm going to take my 600,000 and that must be multiplied by 1.18, and that is my adjusted commencement value. So I started with 600,000. Today it is 708,000, and that is what you are going to then subtract from your ending value. So at the bottom, the calculation of the accrual is your closing value, your date of divorce, net asset value, minus your adjusted commencement value. Let's talk about comparing apples with apples and oranges with oranges. You can't subtract 600,000 because you're dealing with money as it was then and not as it is now. And 5,292,000 is the accrual. And accrual, ladies and gentlemen, you can actually use the word growth. Growth. That is what we're dealing with in accrual matters. You're looking at a deferred sharing of growth. Financial growth specifically, not tummy growth, as in some of our cases. So that is the basics of an accrual calculation. It seems Greek until you actually sit down and you do it. I hate mathematics. Most of us hate mathematics. That's why we went into law, apart from those CAs amongst us who decided to become mediators and do financial disputes, and good on them. It means I don't have to, but know how to do this accrual, know where to find the things. For those of you who do have Jackie Heaton's textbook on law of dissolution of law of divorce and dissolution of life partnerships, she has a fantastic section on accrual calculations, and use that as a reference. Okay, so in the end, after we did our calculations for John and Jane, Jane is 5.2 million, John has 9.8 million. Therefore, John must pay, or well, therefore there is a difference of 4.5 million between them, which means that John must pay Jane just over 2 million so that they walk out on equal footing, so that they, in other words, they share equally of the financial growth in the marriage. Remember, I think I've said it about 1,700 times in this meeting, an accrual is a deferred sharing of growth, and specifically financial growth. Okay, don't ever think again that everything before the marriage is separate, everything after the marriage is shared. That might be the case in some of the EU countries. It certainly is not the case here. Folks, I want to tell you a story. Butters and Ms. Nkora. Their story plays out over a number of years and really comes to a head in 2012 in one of the highest courts in the land, the Supreme Court of Appeal in Bloemfontein. An interesting story about the Supreme Court of Appeal is there's a beautiful photo, and I've seen this with my own eyes, of the courtyard outside the courtroom. There's a bride standing, and that's how you know it's in the Free State. I absolutely love that image. But Mr. Butters and Ms. Nkora's story commenced as follows. They became romantically involved. They never got married. They had a number of children together. Mr. Butters, whose name incidentally was not censored by the law reports, so it is fair game for me to mention the parties by name, had a security company known as, I think it's High-Tech Security Services or something to that effect. The parties' relationship came to an abrupt halt for reasons which really aren't disclosed by the judgment. And the parties then went to court. And the problem that Ms. Nkora was faced with at court is there was no marriage. She was a stay-at-home mom who looked after kids, and he went out and he made a good fortune for himself. So what was she to do? She did something very, very interesting, and it was this. She sued him on the basis of partnership, not in terms of a matrimonial dispute, but on the basis of a business partnership. Now, this was something fairly new in our law, because a lot of people at that stage said, but this is a matrimonial matter. It is not a matter dealing with, excuse me, I'm just quickly reconnecting my PowerPoint. This is not a matter dealing with a business. It is matrimonial in nature. There cannot be a universal partnership. And so the matter went through the High Court, and as it were, the High Court made a ruling and one of the parties appealed. And there was, even in the Supreme Court of Appeal, there was a majority judgment, which was written by Judge of Appeal Brandt at that stage, and there was a minority judgment of which 2 of the Supreme Court of Appeal judges came to a different conclusion. Folks, I'm just going to see if I can share this. Those of you who are here in person, I'm just having some issues with my projector, with my iPad, so I'm just going to share the presentation with you folks, if that is okay. And those of you who are here, please just follow along on your printout. Sorry for the hiccup, guys. So what the majority judgment in Butters versus Nkora actually concluded was this. In this light, our courts appear to be supported by good authority when they held, either expressly or by clear implications, that A, universal partnerships of all property which extend beyond commercial undertakings were part of Roman Dutch law and still form part of our law. B, a universal partnership of all property does not require an express agreement, guys, and this is a point of huge consternation. Like any other contract, it can come into existence by tacit agreement. That is by an agreement derived from the conduct of the parties. The requirement for a universal partnership of all property, including universal partnerships between cohabitees, are the same as formulated by Potier for partnerships in general. And where the conduct of the parties is capable of more than one inference, the test for when a tacit universal partnership can be held to exist is whether it is more probable than not that a universal partnership, that a tacit agreement had been reached. Sure, and I'm going to have to move because we are almost running into load shedding this side. Okay, so what was the upshot of Butters versus Nkora? Number one, if you are in a romantic relationship, even a marriage out of community of property, no accrual, guys, remember what I told you earlier. There can still be a universal partnership between the parties. There can. It can be tacit. You don't have to have a verbal or even an oral agreement. There can be a tacit agreement that there be a universal partnership. Now, folks, here are the requirements. This third block over here is the most important thing that you must remember on universal partnership. These are your requirements. Mediators, attorneys, these are the questions that you're going to lead and ask your clients on in mediation or in a consultation setting. Did each of the parties bring something into the partnership or bind themselves to bring something into it? Something does not have to be something tangible. It can be a skill. It can be labor. It can be whatever the case may be. Secondly, the partnership business should be carried on for the joint benefit of both the parties, not just for the one party, because that's called charity. Thirdly, the object should be to make a profit. If all three of these requirements are met, ladies and gentlemen, you are dealing with a universal partnership. And then the test, as postulated by the Supreme Court of Appeal, the test for when a tacit universal partnership can be held to exist is whether it is more probable than not that a tacit agreement had been reached. Right. Now I'm going to go into forfeiture of patrimonial benefits, which is a very, very contentious topic. There are a lot of judgments in the High Court, which I'm not going to bore you with on these, most of them, in fact, unreported judgments. But be aware that forfeiture of patrimonial benefits is something that exists in our law, and thank goodness my iPad decided to start working again. Yippee. It's something that exists in our law, and it is something that you can potentially, see, I'm sharing the wrong thing over there. Let me just quickly share my screen on my little Apple TV in the boardroom. Okay. It is something that exists. It is something to debate with your clients. Why do I say this? Because, folks, very often we are taught in absolutes. And what we must remember is that in law, nothing is ever absolute, beyond a shadow of a doubt, set in stone. The law develops, the law changes. Look at the position of someone married out of community of property, no accrual. There comes the Pretoria High Court and says, actually, you can still have a universal partnership if the right facts present themselves. Don't fall into the bubble of saying, in community of property, automatically 50-50. Well, yes, that's the default position. But every default position has exceptions. Out of community of property, no sharing. Well, it's the default position. It's not necessarily in all circumstances. Section 9.1 finds itself in this realm, and this is of the Divorce Acts. Lindy, quick answer to that. If it is a sham trust or an alter ego trust, the court can pierce the trust veneer and actually go and include those assets in the matrimonial property regime. We can discuss it a bit later, but that's the quick answer. Thank you for the text. When a decree of divorce is granted on the ground of irretrievable breakdown of the marriage, the court may make an order that the patrimonial benefits of the marriage be forfeited by one party in favor of the other, either wholly or in part, if the court, having regard to the duration of the marriage, the circumstances which gave rise to the breakdown thereof, and any substantial misconduct on the part of either of the parties, is satisfied that if the order for forfeiture is not made, the one party will, in relation to the other, be unduly benefited. This forms part of our law. There was a huge debate, well, not a huge debate, it was more of a storm in a teacup with a judgment of MB versus NB by Semenya AJ in Pretoria a couple of years back. To my Pretoria-based colleagues, I don't know why your High Court always wants to put a spanner in the works. You can send your judges down to Joburg and we'll show them how to just stay the course. But Semenya actually came in and said, well, actually, you know, that we don't have a fault system anymore. But consider this, folks, the Divorce Act of 1979 introduced forfeiture. Fault was done away with as a requirement for divorce in that legislation. Fault is no longer a requirement for divorce, but fault is alive and well in our law, folks. Look at section 9.1, looks at substantial misconduct. Look at section 7.2, When looking at things like spousal maintenance, the court looks at the conduct of the parties. If you were naughty, the court's going to take that into account. So don't fall into the trap of saying that there is no fault in South African divorce law. There is. It's just not a requirement to get the divorce. Everything else surrounding it, we can still talk. Okay, after that preach, let's look at paraphrasing this section, which is quite a bloomin' mouthful, to English. Right. Number one, ladies and gentlemen, the court may order forfeiture. I've put the word may in capital letters. It implies a clear discretion. The court is empowered to make a forfeiture. It is not obliged to. The word must is not used. What you see in forfeiture, folks, if you go look at the case law, the court has a wide discretion, and it really differs from judge to judge how they interpret it. Then, secondly, on forfeiture, you can order either wholly or in part. So you can be ordered to forfeit everything, or you can be ordered to only partially forfeit. The bottom line, guys, is the court must be satisfied that in the absence of such an order, one party will be unduly benefited. Our bottom line when it comes to forfeiture is undue benefit. Will there be undue benefit? For those of you who want to go and trawl through the case law, go and look at Vaker versus Vaker, very, very old case. But basically what that came down to is postulating how a forfeiture is done. One, you must establish undue benefit. Two, how do you establish undue benefit? You look at three things the legislation says. You look at duration of the marriage. You look at the circumstances giving rise to the breakdown of the marriage, and you look at substantial misconduct. You can look at these factors together. You form a whole picture. You have to consider all three of the factors, but you don't need all of the factors to be present. There's a wonderful judgment, and as harsh as I am to my Pretoria colleagues, obviously I see that Judge Jody Collipin has been appointed to the Constitutional Court. What a fabulous appointment. What a judicious judge. And he had a judgment a few years back where there was no misconduct, but the marriage was only 2 years in duration. It was a bitter court marriage, for those who know the old case law where this actually first was adjudicated. And that in that judgment, he actually gave a forfeiture because he said, well, neither party was naughty, but there is going to be undue benefit. You planned to spend your life together. You built everything to spend your life together. Neither of you planned to only be together for 2 years. And he ordered a forfeiture in that case. And I'm happy to share the case law with anyone who would like to see it. That is forfeiture of patrimonial benefits. Now, folks, unfortunately, we have load shedding coming up in my office parks area in 10 minutes time. So I do foresee that I might be cut off. What I will, however, do is I'll go back on with my iPad if we still have a lot of Q&A to just talk through so that we can finish everything. From my side, folks, thank you very much for everyone who attended today. I really, really do appreciate it. Please don't forget about our webinar coming up on the 18th of February regarding estate planning and divorce. And please be sure to register for that one. I'll send reminder emails out to everyone. Thank you so much once again. Thank you for the discussion. Thank you for being here. You guys enable me to do this, and I really, really do enjoy doing this. It is really a privilege for me to be able to chat with all of you twice a month and not have to sit and do file work. Thank goodness. Right, so that being said, we've got 10 minutes before ESCOM cuts us off. Let's go through a few questions. I think let's do I'll plan to do about 10 to 30 minutes of open question and answer and discussion before I'm going to turn my attention to the guys who are physically here for breakfast for the extended Q&A session. Right, so Neil, I know you had a comment query earlier. Has that been resolved, or would you like to talk through it? And now that the jacket has to go, now I'm boiling.
Mervyn, I was luckily answered by Shantae. Thanks for that. She did my research for me with authority.
Also still okay?
Heavy. I just want to know, Mervyn. I recently did a POC for a forfeiture, and it's quite substantial misconduct. And I was just wondering, like saying, in my specific instance, I considered my considerations, and I said, let's make it 30 or 70% of her 50% should be forfeited. I'm just wondering on if the court would ever ask you, or would you need to quantify as to why you're saying an exact specific percentage?
Yes, look at vacant versus vacant. Number one, you have to establish the benefit. Establishing the benefit comes down to the actual financial benefit. What is a patrimonial benefit? So in a big matter that I did, I was very fortunate to work with senior counsel on this matter. How we did it is we went and we did an assets and liability statement of each of the parties at the commencement of the marriage, and an assets and liability statement at the end of the marriage. It was a 5-year marriage. So we actually said to the court, right, court, our benefit or whatever, the benefit is X. Defendant is in control of assets of 2 million. Plaintiff in that case was in control of assets of 32 million. So there's a 30 million disparity. So it's 15 million. It was a 5-year marriage. There was gross misconduct. There was no contribution, and we asked for a full forfeiture in that case. The court has an overriding discretion, Neil, but I like the fact that you say that you actually set out the type of forfeiture, because a lot of people just say, having regard to the defendant should forfeit the patrimonial benefits. If you look at the case law, technically that is acceptable, because you're not placing facta probanda before the court in terms of your allegations to support why you say there must be a forfeiture. So I wouldn't go so far as to say they must forfeit this portion. I haven't, but I think conceivably you can. I think you really, really can. Be careful when it comes to pre-trial to make sure that you quantify your assets and your liabilities so that you manage to place before court the full scope of what the benefit is to the rand, and make sure that you've got agreement on the values of the assets and the extent of the liabilities. Otherwise, you could be faced, in my opinion, with a situation where you may sit with absolution from the instance.
Perfect. Thanks, Mervyn. It's just a awful thing with the let's say us younger attorneys that started with the mediation in practice from the onset in practicing. I kind of want to make the summons so that they see what's the negotiation space. So that's why I said a percentage, but what you say does make sense, that at the end of the day, it's going to be explicit rand and cents. So sometime, maybe not at POC, but somehow you're going to need to quantify that exactly.
Yeah. Neil, it was quite a wild POC that we did in that matter. Our POC alone was 56 pages long. I am happy to, if you just remind me, I'll just redact all the personal information of the parties, and I'll share that with you.
Thank you, Mervyn. That's very nice. Thank you.
All the time. No worries, man. We look after each other. How can I help anyone else? Any other questions, folks? No other questions. I got a cheap round today. Fantastic. Not even from you, Brigitte.
Nope, just learning.
Just learning. Oh, great. All right. Any text questions that I missed out on, Shantae?
No, I think we've dealt with all of them, Merv.
All right. Excellent. Guys, we have 5 minutes to spare. What I will do is I will send out an email to everyone after this with all of the content that we refer to in this as well as PDFs of the slides. Thank you so much for attending, guys. Please connect with me. Please get in touch with me. If there's any way that I can assist you to grow your practice, I would love to help you as far as I reasonably can. My business card, once again, is on the screen. Connect with me on LinkedIn. Thank you for those who have indicated they'd like to be part of our WhatsApp group. Shantae and I will add you after the session. And guys, yeah, thank you so much. I'm so blessed to have been able to share this with all of you. Thank you for taking 3.5 hours out of your Friday to come and listen to this Oki from the West Rand talk some nonsense. I really, really, really appreciate it. I really hope it was of value to you, and I'll see you at the next one on the 18th. Have a fantastic weekend, everyone, and goodbye.